This is how Kyari and when Kyari can be lawfully extradited to the United States of America by Afe Babalola, senior advocate of Nigeria. The Nigerian news media was recently, abused and with the news of criminal charge against Abba Kyari and allegation conspiracy to commit wire fraud and conspiracy to engage in money laundering levied by the U.S. Federal Bureau of Investigation (FBI) in a United States District Court against Mr. Ramoni Abbas, popularly known as Hush Puppy, and others, including Nigeria's highly celebrated police officer DCP Abba Kyari. According to the charge, Kyari arranged the arrest of one Chibuzo at the request of Hush Puppy to prevent Chibuzo from interfering in the scheme, defrauding a victim of over $1 million. Further, in the detailed charge, Kyari allegedly held Chibuzo in custody for a month in order to prevent him from notifying the alleged victim of the impending fraud, and therefore Kyari's knowing involvement in the scheme allegedly allowed Hush Puppy to continue defrauding the victim undetected. Why? Against all human understanding and against the publicity of Nigeria. And Kyari knows that Hush Puppy is into fraudulent acts, and meanwhile he allowed himself to be used by Hush Puppy according to what statement he laid down. And meanwhile, it has been said that Abba Kyari was indicted and also charged to court for involving himself with Hush Puppy. Against this charge, DCP Abba Kyari has been declared wanted for criminal prosecution in the United States of America. I will, in this edition, examine the practicability of and the statutory regime guiding the extradition of a Nigerian to another country, particularly the United States of America, to answer a criminal charge. An appraiser of the extradition law and treaty, the Extradition Act CAP 25 laws of the Federation of Nigeria 2010 generally makes provisions relating to the extradition of persons wanted in a foreign nation for criminal prosecution, which is section 1 of bracket 1 of the Act provides, where a treaty or other agreement in this Act referred to as extradition agreement has been made by Nigeria with any other country for the surrender by each country to the other of persons wanted for prosecution or punishment. The precedent may be or by order published in the Federal Gazette apply this Act to that country. By the above provision, there has been and also to be in existence an extradition agreement or treaty between Nigeria and the foreign country for the provisions of the Extradition Act to apply. However, by section 6 of the Act, an extradition request must be made in writing to the Attorney General of the Federation by a diplomatic representative or consular officer of the country seeking the extradition, accompanied by a duly authenticated warrant of arrest. While the Act generally grants the Attorney General the discretion to refuse to make an order for extradition, but particularly shall refuse to extradite in the following case, i.e., where the extradition is sought in an offense of a political character. If the extradition is being sought to be made for the purpose of prosecuting or punishing a person on an account of his race, religion, nationality, or political opinions, or was otherwise not made in good faith or in the interest of injustice or justice thereabout, but definitely justice is going to prevail, that if surrendered, the person is likely to be prejudiced at his trial or to be punished, detained, or restricted in his personal liberty by reason of his race, religion, nationality, or political opinions. If the nature of his offense is considered trivial, there has been a passage of time since the commission of the offense, if having regard to all the circumstances in which the offense was committed, it will be unjust or oppressive or be too severe a punishment to surrender the offender. If the person has been convicted or acquitted of the offence for which his surrender is sought. If criminal proceedings are pending against the person in Nigeria for the offence for which his surrender is sought, if the fugitive criminal has been charged with an offence under the law of Nigeria or any part thereof, not being the offence for which he is surrendered is sought, or is serving a sentence imposed in respect of any such offence by a court in Nigeria, he shall not be surrendered until such a time as he has been discharged, whether by acquittal or on the expiration of his sentence. If the Attorney General is not satisfied that the fugitive will not be detained or tried in that country for any offence committed before his surrender other than the extradition offence. In addition, the Act empowers a magistrate consequent upon an order received from the Attorney General of the Federation to issue a warrant of arrest of a fugitive criminal executable anywhere in Nigeria, having earlier stated that there must be an extradition agreement with such a foreign country in order for the provisions of the Extradition Act to apply. It is important to consider the bilateral extradition regime between Nigeria and the United States of America. The applicable extradition treaty is the one that came in force on June 24, 1935, when Nigeria was still a colony of the United Kingdom. Though the treaty was between the United States of America and the United Kingdom, Nigeria became bound by the treaty because it was a colony of the UK as at when it came in force. At Nigeria's independence in 1960, the treaty became applicable, as was the case with all laws inherited from the United Kingdom. Since then, the extradition treaty became part of the nation's legal system. This treaty, however, became validated by the provisions of Section 1 of the Extradition Act. Article 1 of the Extradition Treaty provides that contracting parties engage to deliver up to each other under certain circumstances and conditions stated in the present treaty, those persons who being accused or convicted of any of the crimes or offences enumerated in Article 3 committed within the jurisdiction of the one party shall be found within the territory of the other party. The crimes to which the treaty may apply were listed under Article 3. It includes the offence of obtaining money, valuable security or goods by false pretenses, receiving any money, valuable security or other property knowing the same to have been stolen or unlawfully obtained. It is on the strength of this provision that the government of the United States of America has, through its Federal Bureau of Investigation, obtained an order of court for the arrest and extradition of DCP Abba Kyari from Nigeria to stand trial for the crimes of conspiracy to commit wire fraud and conspiracy to engage in money laundering. Yes, the prohibition of extradition will also be applied, but as it is, Abba Kyari is going to be extradited, and because there is a provision from the Constitution that says it is an agreement between Nigerian government and the United States that extradition agreement needs to be followed. Well, I would like you to share your comments in the comment section.